Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning your case. Now, the paperwork that you have in your hand, I will go over that paperwork with you. County Court at Law Number 2 is a misdemeanor court, and that simply means that the cases that we handle are misdemeanors. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type cases, and your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious. And when I say serious, we're talking about the range of punishment. That is what you can be sentenced to after being convicted of committing one of these crimes. Now, your felony cases are divided into, I guess, 5 categories. The highest is a capital murder, and then it goes down to a first-degree felony, second-degree felony, third-degree felony. And the lowest felony is a state jail felony. State jail felony range of punishment is anywhere from 6 months to 2 years in the state jail, and a fine up to $10,000. The third-degree felony range of punishment is from 2 years to 10 years in the state penitentiary, a fine up to $10,000. Second-degree felony range of punishment is 2 to 20 years in the state penitentiary, a fine all the way on up to $10,000. First-degree felony, the range of punishment is 5 to 99 years to life in the state penitentiary, and a fine up to $10,000. Capital murder range of punishment is life or death. Now, the offense that you have in this court, as I said earlier, is classified as a misdemeanor case. Misdemeanors are divided into 3 categories. The highest category is a Class A misdemeanor, and then we have a Class B misdemeanor and a Class C misdemeanor. Class C misdemeanor is your lowest misdemeanor. Now, for a Class C misdemeanor, the range of punishment is a fine only. You only can get a fine for a Class C misdemeanor. Normally, the fine is up to $500. For a Class B misdemeanor, the range of punishment is from 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000. For a Class A misdemeanor, the range of punishment is 0 days to 365 days in the county jail, a fine from $0 to $4,000, or for any one of these offenses, these misdemeanor offenses, you could get either that, you could get what we call probation, okay? So you could either get a jail time and a fine, or you may qualify for what we call probation. Now, the forms that you have in your hand concern a right that you have. Now, as a defendant, you have several rights. One of the rights that you have is a right to have an attorney. The first page on the documents that you have in your hand is titled Judge's Explanation of Rights to Defendants Without Attorney. Now, as a defendant in a criminal case, you have three options. One, you may hire an attorney. Two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or three, you may represent yourself. Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, at the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset my case to hire an attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Now, if your choice is I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed a court-appointed attorney, you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Or if your choice is I want to waive my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, you will place your signature on the line that says defendant, and you will place today's date, which is March 29th of 2022, on the line that says date. Now, if you are waiving your right to an attorney and you are desiring to represent yourself, then you'll have to read and sign the second page. The second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 29th day of March 2022 by the County Court at Law, number 2, of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right. And if that's your choice, then you will sign on the line that says defendant. You place your signature on that line that says defendant and today's date, which is March 29th of 2022. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a trial by jury. And where all those young people are sitting in the jury box, we call that the jury box. And that area over there is where the jury will sit if you decide to have a jury trial. And what a jury will do, they will listen to all of the evidence in the case. And after listening to the evidence, they will deliberate and they will decide whether or not you are guilty or innocent. Now, you have a right to waive your right to have a jury trial, and that means that you have a right to give up your right to have a jury trial. And by doing so, you would not be having a jury trial. Now, your case can come before the judge after that, and if you decide not to have a jury trial, in one of three ways. One way, if you still want to have a trial but without a jury, it will come before the court or the judge by way of a bench trial. A bench trial is a trial without a jury. It's a trial before the judge, and the judge will decide, after listening to all of the evidence, whether or not you are guilty or not guilty. Your case will come before the judge in another way as well. The second way it can come before the judge is by way of an agreed plea bargain. That is, if you or your attorney and the state has reached an agreement to settle your case, then your case will come before the judge. And the judge will decide whether or not the judge will follow or not follow the plea bargain, go along with the plea bargain or not go along with the plea bargain. Now, if the judge does not go along with your plea bargain, you'll be entitled to withdraw your plea, which means you can take your plea back if the judge doesn't follow the plea bargain agreement that you have reached with the district attorney's office. Now, if the judge does follow the plea bargain agreement, and if you decide that you would like to appeal your case, that is, you would like a higher court to review your case to determine whether or not the court has committed an error by convicting them, whether or not you have been wrongfully convicted, then you have to get permission from the judge. You have to get permission from the court to appeal your case if the judge follows the plea bargain agreement and you want to appeal. Now, the third way that your case can come before the court is by way of an unagreed plea bargain. Unagreed plea bargain means that you would like the court to determine your punishment because you and the state, that is the district attorney's office, have not been able to come to an agreement on the punishment. And so you want the judge to decide what the punishment will be in your case. That's an unagreed plea bargain. So if you waive your right to a jury trial, your case can come before the judge in three ways: by way of a bench trial, that's a trial before the judge only; by way of an agreed plea bargain, if you have an agreement to settle your case with the DA's office; or by way of an unagreed plea bargain. That is, you want the judge to determine what the punishment is because you and the state have not been able to reach an agreement. Now, you also have a right to have witnesses in your trial. You have a right to call witnesses on your behalf. And what a witness do, they can testify for you or they can testify against you. Now, you also have a right to waive that right to call witnesses or give up that right to call witnesses. And if you waive your right to call witnesses in your case, you will not be calling witnesses, but it does not mean that the state or the district attorney will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have a right against self-incrimination. Self-incrimination means you have a right not to testify against yourself. In essence, you have a right not to testify in your case. We call that the Fifth Amendment right against self-incrimination. And you have a right to waive or give up that right if you desire to. By waiving your right against self-incrimination, that simply means that you will be testifying on your behalf in your case. Now, also, you have a right to have discovery. Discovery means that you have a right to see the evidence that the district attorney, state of Texas, has against you in your case. That is, you have a right to see the videos, you have a right to DVDs, you have a right to hear tape recordings, you have a right to see documentary evidence, you have a right to see witness statements, physical evidence or objects, or whatever evidence that you have a right to see and inspect the evidence. Now, you can have I guess the law says you can have access to that evidence. Now, also, I should mention that you have a right to enter one of three types of pleas. You can enter a plea of not guilty, and if you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you could enter a plea of no contest. If you enter a plea of no contest, then you're telling the court that you will not be fighting or you will not be contesting the charges that the state has filed against you. Everyone in here, you're here because you have bonded out of jail. Either you're on a cash bond, a personal recognizance bond, or you may be here on a surety bond. But in any event, you're here, you're out on bond. Now, every day that you spent in jail, that time can be used as credit toward your punishment. Now, if you enter a plea of no guilty, no contest, and you and the state are able to work out an agreement, and if that, for example, if the state is offering 5 days in jail, you spend 5 days in jail, that simply means that you will not have to spend any more time in jail, because the 5 days that you spent in jail will be used, it will be called credit for time served. You've already served 5 days in jail, so you won't have to serve any more time in jail. Now, if they're asking for 7 days in jail and you serve 5, that means you have to do 2 more. Now, every day that you spent in jail as well is credited as $100 per day that can go toward your fine and court costs. So if you spent 5 days in jail, that's $500. And if the state is offering you fine and court costs of $500, that simply means you won't have to pay anything. Why? Because the 5 days in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay anything. Now, if they are offering more than a fine of $500 in court costs, if they're offering a fine of plus court costs of $700 and you did 5 days in jail, that means you have to do $200. But let's say you can't pay the $200 because you just don't have it at the moment. Then the court can put you on what is called a payment plan. You can pay it off in monthly installments until it's paid off. But let's say even if they put you on a payment plan, you won't be able to pay it off because you do not have a source of income. If that's the case, then the court can convert your fine and court costs to community service. That means that you can work in the community at some nonprofit organization, and every hour that you work at that nonprofit organization, $12.50 will be credited toward your fine and court costs. So you'll be getting like $12.50 an hour. And if you work 8 hours, that's $100 for that day. Now, Jefferson County has a program for first-time offenders. That program is called pretrial diversion. With pretrial diversion, if you get in the program, they will dismiss your case and you can get it expunged from your record. And what an expunction is, when I say expunged from your record, that means it'll be erased, deleted, or wiped off from your criminal record, the charge. The way it works, you have to get an attorney to make the application to get into the program. You cannot have an offense for unlawful carrying a weapon or resisting arrest. And it has to be your first offense, so you can't have a criminal history. And as I stated earlier, if you get into the program, they'll dismiss the case. Once they dismiss the case and you complete the program, then you can get it expunged, which is deleted, erased, or wiped off from your criminal history. If you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. And with Veterans Court, it's the same thing like pretrial. You get into the program, complete the program, they dismiss the case, you can get it expunged from your record. And so I think the only criteria for Veterans Court basically is being a veteran of any one of the branches of the United States military. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative. Community Safety Initiative is a program that is designed to make Jefferson County a safer place. And the way the program works is we have a partnership with agencies in the community. We have a partnership with those young ladies sitting in the jury box there with Spindletop. And so we have a partnership with Spindletop. Spindletop is our local mental health agency, and they can do private interviews. Spindletop can do an assessment. They can do a treatment plan, either for outpatient or inpatient treatment. Now, in order to be in the program, you don't have to be insane. You don't have to be incompetent. You could have maybe suffer from anxiety, depression, bipolar, schizophrenia, post-traumatic stress, or a whole host of other mental illnesses, and they'll be happy to interview you and see what they can work out with you to meet your mental health needs. Now, if you have issues, problems with drugs and alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And with the ATAR program, and that's for individuals who I think 21 or younger, they can do screenings, assessments, and develop treatment plans as well. For anyone who have problems with drugs and alcohol, it could be outpatient or inpatient treatment. The other thing is OZAR, which stands for Outreach, Screening, and Assessment Referrals. They are our local alcohol and drug abuse council. They'll be able to also provide drug and alcohol screening, interviews. They can develop treatment plans, and they can refer you for outpatient or inpatient treatment to address your drug or alcohol problems. Now, if you are unemployed and do not have a job, we have a partnership with the Golden Triangle Empowerment Center. Empowerment Center has a partnership with Lamar University. Lamar University has a program that's called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas that you select, they will assist you at getting employment in the area that you're trained in. If you have not graduated from high school, they have a program, CICE, it's a GED program, where it can help you to get your graduate equivalency diploma. Now, all of those programs that I've just mentioned are free. It does not cost you anything. Only thing you have to do is have a desire to be in one of the programs, and we have brochures and information that we can give you. The other thing is that all of these programs, not only is free, but all of these programs could be used as community service toward your punishment. So for example, if you cannot pay a fine, court costs, we convert your fine and court costs to community service. And let's say if you're in one of the programs that while you're in the program, say for example, job training, while you're being trained for a job, 1 hour, every hour that you sit in the class, that hour will go toward community service, and $12.50 will go toward your fine and court costs. So you'll be doing 3 things. You'll be doing 1 thing, but you're getting credit for 3. I always like to use the phrase, we can kill 3 birds with 1 stone. In essence, you're paying your fine and court costs, you're doing community service, and you're in the program. And that applies to the drug and alcohol program, the mental health treatment, the job training and job placement, as well as the GED. So if you're interested in any of those programs, just let us know, and we'll be happy to assist you at getting into those programs. Now, I tell people this all the time: when you come to County Court at Law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but because we're trying to make a difference in the lives of the individual that comes in this court. And we're also trying to make a difference in Jefferson County. in County Code at Law number 2, we do not, we do not just give time, we take our time. And the reason why we take our time, because we believe that we don't want to just arrest the problem. We want to address the problem. If we address the problem, we believe that we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. And so those are the programs that we have here in Jefferson, in County Code at Law number 2. Those programs were started in March of 2017. So it's going on 5 years since the program has been going on. And I could say hundreds of people have been involved in all of those programs. Hundreds of people have been helped. Now, at this time, we're going to have someone from Spindletop, Deputy Hinton. He's going to come and tell you a little bit about the program that they have at Spindletop. Deputy Hinton. You're welcome.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed out of the state of Texas. I'm here with two people, Sarah and Chris. Now, they're both qualified mental health professionals. And with Spindletop, now the reason we're all here today is because the judge cares about every single person that comes before his court. The judge has found that most people who come before his court with legal issues commonly have either mental health or substance use disorders. If this applies to you, the judge believes that if we can address those issues with you, we can help get you out of the cycle of arrest. Now, maybe this is your first time to be here. Maybe it's your 10th time to be here. You're still home. It's going to require one thing from y'all, and it's going to be, you're going to have to share that need with us so that we can help you in that manner. And your information is completely private. It's HIPAA regulated. We cannot speak of it outside your permission. But one thing I want to also show you, we have this flyer on the back that tells you a little bit about our court program. And on the front, they have a 1-800 number, which is a crisis number. Should you ever find yourself in the same place, you can call that number and get help immediately. Now, what's going to happen from here is when the judge goes into recess, Sarah and Chris and I will be coming out. We'll visit with y'all, get an opportunity to speak with you privately. And if this is something that you think would benefit y'all, then we'd ask you to visit with us and share that information with us. Maybe this doesn't apply to you, maybe it applies to a family member. If it does, we'd still like to get this information in your hands so you can get it to your family. And we'd be glad to work with y'all for your family to help them as well. Should this be something that y'all see value in? Again, thank you very much.
Okay.
Thank you, Your Honor.
All right, thank you, Deputy Hinton. Now, ladies and gentlemen, it's going to take a few minutes. That information that you filled out on the clipboard, we're going to have somebody from the staff come and collect that information from you. And once we go through that information, we're going to call you up to the bench one at a time. So at this time, we'll be in recess